I know much has been in the news lately, and most recently about Glenn Ford's death. This is a case that I think illustrates probably better than any other the real significance of experience in the office. In Mr. Ford's case in 1983, he was prosecuted for the murder of Mr. Isidore Roseman, who was a jeweler who had a shop on Stoner Avenue near Centenary Boulevard. I'm not sure, and I don't think Mr. Roseman's shop is there anymore. But the decision was made to prosecute him in 1983 for the murder of Mr. Roseman, and several other people were arrested as well. And a jury convicted Mr. Ford and recommended the imposition of the death penalty. The Louisiana Supreme Court affirmed that conviction and found that there was sufficient evidence to support that conviction and that penalty. And for 30 years thereafter, every judge who heard the case thought that the evidence was sufficient. In 2013, while I was acting as Judge Scott's first assistant, I was involved in investigating a completely unrelated homicide that had nothing to do with the Roseman homicide. And in the course of that investigation, I came into possession of some new information that we had not possessed before as a district attorney's office. When I got this information, I immediately realized it had a lot of significance and it was true. And so we set about trying to verify the credibility of the information and the credibility of the source of the information to determine whether it really, as they say, had legs to it, if it was something that was credible and that we should go and act on. We determined, and I say we because there were a group of lawyers in our office, the more senior lawyers, who reviewed this with me and concluded that yes, this information was credible. And because it was credible, we felt the need to act on it. Judge Scott was very instrumental in these discussions that we had within our office. It was my recommendation, and ultimately Judge Scott agreed, that because of the passage of time, 30 years, there is no way we could retry Mr. Ford and submit this new information to a different jury, because much of the evidence in the original case had been destroyed or lost. A number of witnesses from the original case had died, including Dr. McCormick, whose testimony was very instrumental in the trial. And so quickly came to the conclusion that the only right thing to do and the only fair thing to do would be to release Glenn Ford from Angola. And even then, we had two choices we could make. We could allow the matter to be handled by Glenn Ford's lawyers in the federal system where it was. See, at the time we learned of this information, the state no longer had jurisdiction over Glenn Ford's case. It was in federal court. And he was seeking habeas corpus relief in federal court. So we, the state district attorney, really didn't have any authority to do anything in Glenn Ford's case. So we discussed two possibilities. One is that we would just turn this information over to Glenn Ford's lawyers and let them take the necessary action to secure Mr. Ford's release from Angola. Or we could petition the federal court to give us the case back. In other words, to transfer jurisdiction back to us so that we could move to vacate his conviction and sentence. We decided to choose the latter. We'll turn this off. We chose the latter course because I thought that it would be the quicker course. If we had allowed this matter to proceed in federal court, it would have taken another year or two. By the time all the lawyers got filing all the paperwork and everybody took their respective positions, because as everybody knows, justice is very slow. And so, given the circumstances of Mr. Ford's case, we decided that we would ask the federal court to give us the case back, and they did. And then I moved to vacate his conviction and his sentence. And our state district judge, Ramona Emanuel, to whom the case would have been assigned if it had happened now, she accepted jurisdiction and she signed the order allowing Mr. Ford to be free. And he was free, I believe, that same day or the day after. And while that is a good thing, it was also a very tragic outcome. It was a tragic outcome for a number of reasons, one of which is that Isidore Roseman's murderer is still at large. Absolutely. And Mr. Roseman never hurt anybody. He had a nice little jewelry shop there on Stoner, and several people, we believe, broke in and murdered him in that shop. It was a tragedy for Glenn Ford because he spent a lot of time, 30 years on death row, when, if this new information had been available in 1983, he may not have been convicted at all. And that's what I struggled with. If this information had come to light 6 months after the conviction, it would have been a much easier thing to deal with. We could have simply given him a new trial and taken the new information and presented it to another jury, and the jury would have decided whether that information was adequate enough to change things. I came to the conclusion that it's likely that a jury would have changed things. In fact, I think our own prosecutors would have changed things had they had this information. And let me emphasize here that our prosecutors did not have this information. No one had this information except the parties who ultimately came forward. And then they only came forward 30 years later. So with that in mind, Mr. Ford was released. And of course, in the interim 30 years, he had contracted cancer. And he fell gravely ill after he came out of the penitentiary. He came back into New Orleans, where he was from, had family in New Orleans, and of course that's where he died yesterday. And I have been asked by a lot of people, both locally and nationally. I've been asked by 60 Minutes, New York Times, the New Yorker magazine. I've given interviews with all of them, and they all want to know the same thing. How could that happen, and how could that be avoided so that it would not happen again? And there is no easy answer to either question. But I think we can draw certain instructive things from Mr. Ford's case. Number one, I think it is very, very important, in fact critical, that there be a committee in the district attorney's office of the most seasoned lawyers. And we have such a committee. Dew is on that committee, and several of our other most seasoned lawyers are on that committee. And I think it is critical that whenever you have a case that first comes in the office, that you just don't have one lawyer look at it, that you don't have just one prosecutor look at it and say, I think he did it, and I think he deserves the death penalty. You need to have 5 or 6 of your most seasoned people look at it and discuss it and debate it and argue about it. And because I think then you get a better sense of what the real facts are and whether it is the kind of case that you would seek to have the death penalty in. We have such a committee now in our office, and I'm proud to say that we have already considered some cases. Dew and I have a case that we're going to present to that committee this Friday. It was a case where the young man was shot at Bilberry Park, a 13-year-old young man. And we have to decide what we're going to do with that case. Are we going to prosecute it as a first-degree murder? Are we going to, if so, are we going to seek the death penalty? And there are a lot of variables that go into that decision. It's not just one thing. It is a whole host of criteria that we as the lawyers have kind of cobbled together over the course of our experience because we feel like these are the criteria that are important to making this decision. I think that lesson is instructive for us in the Glenn Ford case. I do not believe in 1983 there was such a committee in existence. And I don't mean to disparage the prosecutors there because I think they made good faith judgments based on the information they had. I just think it's a better procedure if you can have more eyes and more heads looking at a particular issue than not. I think a second lesson that can be learned from the Glenn Ford case and can hopefully avoid another tragic outcome like that is for the prosecutors to maintain a continuing dialogue with law enforcement. You see, because this new information that came to me in 2013 came indirectly from law enforcement. They had street information that I didn't have. And once they brought the street information to me, I made the legal decision. So I think it's important for prosecutors to continue to have dialogue with their investigators on a case. And one way we do that now, and have been doing that in the recent past, is we will send a letter or we will have conversations with the lead investigators that tell them, if you come across any information that leads you to think we have the wrong guy, or if you come across information that leads you to think there's something in that guy's favor that we didn't know, you must tell us about it. In fact, the United States Supreme Court, in a case called Kyles v. Whitley, has made that a legal requirement for prosecutors. That we are presumed to know what the police know, whether we actually know it or not. So since we're going to be presumed to know something, I think we should take the initiative and actually know it. And the only way you can actually know it is to tell your law enforcement agencies you must keep us abreast. Because I tell you, as you fluid thing. It changes every day, and information comes in every day. Off the street, from informants, paid and unpaid, from concerned citizens, from every source you can imagine. Police are always getting tips. They're always getting information. Some of it's good, some of it's not so good. What we tell our law enforcement people is it doesn't matter. You let us worry about whether it's good or not. You just tell us about it. We'll follow up. We'll make the necessary decision. I think those two things, had they been in place, would have helped avoid this tragic outcome. The thing that I've asked most often is then why don't we do away with the death penalty, and that way we won't ever have to worry about something like this happening again. Let's just do away with it like a number of other states in our union have done, most recently Nebraska. And Nebraska is no liberal state. They're very conservative. And they overrode their governor's veto and decided, no, we're not going to have a death penalty in Nebraska anymore. And to me, and I'm probably one of the strongest proponents of the death penalty, to me, I say, amen, that's great. Because it's the people making the decision. It's not the federal government telling us what the decision is, it's the people making the decision. I think it's very important in any discussion of the death penalty to start with the proposition that it is the law here. And it didn't just happen to get to be the law. Our legislators voted on it and have consistently voted on it and have consistently said it is the law, which means the people have voted on it through their elected representatives. Now, a lot of things get said about the death penalty, and people get very, very angry on one side or the other. But as with all things, I think a little light on it is better than a lot of heat on it. And the truth is, you're not even subject to the death penalty in this state unless you've already committed one of the most horrible crimes anybody can imagine. You don't get the death penalty just for going out and shooting some guy across the street. That's a second-degree murder. You only get the death penalty when you've done the worst of the worst of the worst. And then you're just subject to it. You don't automatically get it even then. And our legislature, as approved by the United States Supreme Court, has put into place a very thoughtful scheme whereby juries make this decision, incidentally, not judges. A very thoughtful scheme where juries consider all the good things about the guy or the girl and all the bad things. And the jury makes the decision whether under these circumstances, unanimously, everybody has to agree. Yes, we think you did it, and yes, we think you deserve the death penalty because what you did is so bad that our legislature has said when you do something so bad, you forfeit your right to live among us as a civilized society. I think that's a perfectly good scheme. Would I be happy tomorrow if Louisiana abolished the death penalty? You bet I would. Because that would take the burden off me and off all of my prosecutors and prosecutors throughout this state to make one of the most difficult decisions you could ever make in your life, and that is whether to be the person or persons who actively seek to kill someone else in the name of the people. As far as I'm concerned, that's about as serious as it gets in terms of decision making. So I would be very happy to be relieved of that burden. And I suspect if you ask Dew or any of our seasoned prosecutors, they'd say the same thing. They'd be very happy not to have to make that decision. So no, I'm has already said, the death penalty is not cruel and unusual punishment. For this man who came into the church of Charleston last week and killed all those innocent people, I think that's the kind of case for which the death penalty should be approved. That's what the legislature had in mind. That's what the people had in mind when they defined first-degree murder as the killing of more than one person. That'll get you the death penalty. If you had the intent to kill more than one person, you're eligible in this state for the death penalty. And he very obviously went into that church with the intent to kill every living, breathing soul in that church. And it wasn't for lack of effort that he didn't kill everybody. And I hear all of this about, yeah, he's nuts and all that, but he's also responsible. And so when I think of the death penalty, that's what I think of. That kind of case. And I fully respect anybody who opposes the death penalty. Because I used to. I started out as a prosecutor in 1976 under then District Attorney John Richardson, and there's probably just a few of us old enough to remember John Richardson. He was the District Attorney before Paul Parish, who was the District Attorney before Charles Scott. But in 1976, and I stayed with Mr. Richardson until 1983, we didn't do any death penalty cases. And I myself could not do it because I was morally opposed to it. And that had in large part to do with my religious upbringing. I was raised in Catholic schools here at St. John's, a Jesuit high school. And the Catholic Church has a strong position against the death penalty. And that influenced me greatly in my earlier years as a prosecutor. The American Conference of Catholic Bishops has taken a very strong approach against the death penalty. And so I didn't feel like I could do it. And I had plenty of chances to do it, and I never did it. But I also realized if I couldn't do it, I didn't need to be a prosecutor because I was violating the law. You can't pick and choose when you're a prosecutor which laws you're going to enforce. For example, if I didn't like burglaries, I'd say, well, I'm not going to prosecute anybody for burglary because I don't like it. You can't do that. You're sworn to uphold the law. And first-degree murder and the imposition of the death penalty is the law. So I got out and went into private practice for 30 years. But I did miss the trial work. I missed it a lot. I missed the thought that you could do some good in the community by trying to right wrongs that had been committed, by trying to bring people to justice who had violated other people's lives and rights. And so I came back initially as a special prosecutor and then in 2011 full-time again. But my position on the death penalty had evolved over time. I know you've probably heard from Mr. Stroud, Marty Stroud. He may have even spoken to your group, but I know you've read or heard about his evolution the other way. He started out very much strong for the death penalty. And over time, his position has evolved to where he does not agree with it and thinks it should be abolished. And I respect that position. I used to hold that position. But I began to see over the course of time, and this is over a period of 35 to 40 years, I saw in our community, and not just in our community, nationwide, a level of savagery and heinousness and violent crime that I had never seen before. My first murder case in 1976 was a guy who came into a bar room and shot another guy one time in the chest. Boom, that's it. Today, juvenile and others see people who break every bone in a 6-month-old baby's body. Or take an 86-year-old man, choke him to death, and then cut off his head, and his arms, and his legs, and then bury him throughout the parish. So, in a period of one generation, which I'm calling about 40 years, I have seen it go from a one-shot barroom argument to almost cannibalism. And that is what has changed my position on the death penalty, that I think we are seeing a level of savagery which reflects a complete destruction of any notion of a civilized society. And to me, just putting you in jail for things like that is not enough. It's not enough for the people. That's why the people want their legislatures to have a death penalty. And please don't misunderstand what I'm saying today. The death penalty is only 1/10 of 1% of all the cases we handle. Our business, 99.99% of it is everyday crime. And I don't mean to dismiss everyday crime as any less serious, but it's the theft, it's the forgery, it's the burglary, it's the drug cases, it's the rapes, it's the child molestation. And those are all very, very serious, but they're not death penalty cases. So an inordinate amount of time and an inordinate amount of attention is paid to death penalty cases when they really only make up a very, very, very small fraction of what we do, but it is a critically important fraction of what we do. And so that position has evolved over time, and I have received a great deal of criticism for it. Our office has received a great deal of criticism for it. The New Yorker magazine published an article on me yesterday in which I think I was called everything but it. I was called Darth Vader. I was accused of having a brain tumor, and I was accused of being mentally ill because I had the temerity to suggest that when you smother an 8-week-old infant to death and beat him about the head, you should die for that. If that's the case, they were interviewing me on. So I respect Mr. Stroud and anybody who opposes the death penalty, but I also understand the other side of it because I live in the other side of it. I think as you make a decision for district attorney, I would encourage you and the people you know and the people you have influence with to consider these things. And to consider that whomever you choose for that office be very experienced, have tried many, 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 many cases, have dealt with many, many, many fact situations. Dude has a tremendous history of experience coming out of New Orleans Parish. God, you'd think we had cases. But they have is literally incredible. And dude has tried many, many cases since he's been here. Consider experience when you consider your candidate for district attorney, because I really do believe, and you hear this a lot, but in this business there is no substitute for it. You do not get a second chance. You do not get to learn on the job because you're learning the job with other people's lives. Now, those are the lessons that I can draw from the Glenn Ford case. I think I would be remiss if I did not comment on one other subject that I have seen evolve or degrade over the course of time, and that is we have an absolute epidemic of child victims. in our community. I have gone from seeing no cases involving child abuse, not any, in 1976, and now we carry 50 to 100 child abuse cases at any one time. And when I mean abuse, ladies and gentlemen, I mean abuse. I mean burning a baby alive in scalding water. I mean breaking every bone in a 6-month-old baby's body. I mean smothering them to death. I mean hitting them so hard that their brains swelled so much that their throat swallowed their brain because there was no place else for it to go. And we are seeing an epidemic of that in our community, and I believe that this epidemic, and I believe that the heinousness and savagery of the first-degree murder cases that I described to you earlier, I'm asked and was asked, well, isn't it the result of injustice? Isn't it the result of poverty? Isn't it a result of income inequality? Isn't it a result of lack of educational or employment opportunity? And I say no. Those are symptoms of it. The cause of it is the destruction of the nuclear family. I have prosecuted young men and young women as a career for 40 years. I have never, one time, never once prosecuted a young man or a young woman who came from a two-parent home. Not once. You can call that coincidence if you want. I don't call it coincidence. I call it the root cause of what I believe is increasingly the destruction of our society. Because when young men and young women come from a two-parent home whose father has a job, they are more likely to be disciplined by their father. In the home, they are more likely to be taken to church. They are more likely to be educated and fed well and clothed well. They are more likely to make friends and learn how to make social solutions as opposed to violence. They are more likely to get and keep good jobs and have good families of their own, and they are less likely to commit crimes. Because they know if they steal something, like a bike, and their dad finds out about it, they'll never steal another bike again. And that's where you stop it. Everything else is a symptom of that. And this is just my opinion. I don't offer you any scientific study or empirical data or law review article. This is just what I've observed over 40 years of time in this community. And having said that, I'll have to say that even those situations are a small fraction of our community. Our community, by and large, is made up of two-parent families who do discipline their children, and that's why we don't have any war crime that we have. But I think it's also why this nature of the crime we have is more savage. When you don't have that underpinning of what I'll call moral persuasive authority. I learned a lot from John Richardson. I learned a lot from the lawyers who were in his office, Judge Charles Lindsay, Judge Fred Sexton, Judge C.J. Bolden. I learned a lot from the good lawyers in Paul Hermich's office, Howard Fish, Laura Fulco, Suzanne Owen. I learned a lot from my colleague Lou Thompson and others that now work with us. The only thing I can say to you is, as a candidate for this office, that is all I can offer you, is that experience. And that will either be enough or it won't be enough. But you're not going to see me on TV. You're not going to see me send you a fundraiser, because there there aren't going to be any fundraisers. I'm not asking for any money from anybody. And I don't want to owe anybody if I got elected to that position. And when you take money, you take what goes with it. So I ain't taking it.